Jackie Dean.
Thank you, Mr. Speaker. I want to thank also the previous speaker and his good summary of the provisions of the Evidence Amendment Bill. And as we work our way through the third reading, which means that we are getting ever closer to the enactment of this important piece of legislation, I just want to preface very few comments about the contents of this bill with a number of other initiatives that we have undertaken in this government to put the victim at the heart of the justice system, and particular in this case pertaining to this bill, provisions around protecting children as they give witness in court trials. We've already done a number of measures to support the fight against family violence. There was the introduction of police safety orders to help manage family violence situations. We now have up to 1,000 victims of family violence who are now kept safe in their own homes, and that is by way of the new National Home Safety Service. And what that has allowed victims to do is for some considerable time who have felt fearful and afraid, now with some very simple interventions like alarm systems and locks on windows and doors and other measures, feel safe in their homes for the very first time. There is a ministerial group, and that's ministers across 16 portfolios who are focusing on family and sexual violence, which will oversee a whole-of-government strategy for addressing family and sexual violence, and of course recently announced last week a complete overhaul of family violence laws. And I do expect and hope that the Select Committee in charge, if it's the Justice Committee, will consider that bill with a lot of serious attention. The main provisions of the third reading, this Evidence Amendment Bill, I won't go into in too much detail. I think in the third reading, with agreement across the House, I think the provisions have been well rehearsed over the course of the passage of this bill. I do just want to touch on the provisions around the changes in court processes for those vulnerable witnesses, and in particular children. And it is around the presumption that child witnesses give evidence in alternate ways and have a right to a support person. So currently under the Evidence Act, the prosecutor have to apply to the court for the use of alternate ways of giving evidence, and the judge must then give her or his permission for a child witness to have a support person. One of the very strong recommendations of the Law Commission, and one of the very strong submissions made to the Justice and Electoral Committee when we were considering this bill, that fundamentally that was a provision which needed to be brought up to date to recognise the rights of children and the needs of vulnerable children when they are required to give evidence in court. So along with the presumption that all child witnesses will give or will use alternative ways of giving evidence, it also gives children the right to have a support person. And for those two provisions alone, it is a very good reason for us to enact this bill with not undue haste, but I think with all speed. It is a bill which enjoys wide support through this House, so it should do, because this bill better protects vulnerable witnesses, and also while ensuring that evidence is heard and handled appropriately and securely. Look, we never can legislate our way out of the pain and suffering caused by victims, but what this Parliament is doing, rightly, is ensuring that vulnerable victims and witnesses are better supported through their participation in the justice process. With those comments, again, I want to acknowledge the hard work of the Justice and Electoral Committee in commending this bill to the House.